Good afternoon. Today, I address hidden professional conflicts in Chapter 11 cases. It has been 40 years since the Bankruptcy Code was enacted. By now, the crucial importance of Section 327 and Rule 2014 are clear. Those provisions of law help establish and maintain the integrity and fairness of the bankruptcy process, as well as the confidence of the parties and the public in that process. But unfortunately, we are still fighting about disclosure and about what it means to be a fiduciary. So let's look at some cases. These are cases that you will see immediately that we are still fighting. And I won't have to explain it to you. Case number 1. Professional A, a large consulting firm with offices around the world, was retained as a professional for the debtors in 10 Chapter 11 cases from 2001 through 2016. Professional A had numerous client and investment connections in each of these cases, but never disclosed the identity of any of those connections in its initial declarations, and only one connection in a supplemental declaration in one case. In several of the cases, undisclosed clients of Professional A acquired the assets of the debtors. Case number 2. Professional B was retained as a professional for the debtor in a Chapter 11 case. Professional B has a wholly owned and controlled investment office that has $33 billion in assets under management. Most of these assets consist of the investment funds of its current and former partners. A much smaller portion consists of its employees' retirement assets. It has no other assets under management. Through this investment affiliate, Professional B had invested in the W Fund, and Professional B was aware that the W Fund held senior secured debt in the case. Therefore, the partners and employees of Professional B had a financial interest in the outcome of the case. Professional B did not, however, disclose this financial interest in the senior secured creditor. The judge in the case entered an order requiring Professional B to disclose all of its investment interests in parties and interest in the case. However, Professional B still did not disclose this financial interest in the senior secured creditor. After the senior secured creditors, including the W Fund, acquired the debtor's assets through the plan, Professional B's partners and employees made a multi-million-dollar profit on this investment. Case 3. Professional C was retained as a professional for the debtors in a Chapter 11 case to maximize its pricing to its customers. Professional C, however, failed to disclose that at the same time and with the same partners, it was also advising a major customer of the debtor on how to reduce its pricing of the debtor's contracts. Case 4. Professional D was retained as a professional for the debtor in a Chapter 11 case to investigate the debtor's fraudulent transfer claims against its parent company, totaling hundreds of millions of dollars. Professional D, however, did not disclose that at the time of these alleged fraudulent transfers, the debtor's parent was also its client. Case 5. Professional E was retained as a professional for the debtor in 2 different Chapter 11 cases to review creditors' proofs of claim and to file objections to them. Professional E, however, did not disclose that many of the creditors whose claims it was reviewing in these 2 cases were also its clients and investments. Case 6. Professional F was retained as a professional for the debtor in a Chapter 11 case. In its initial disclosure declarations, Professional F disclosed about 150 client connections. Before the court could rule on the objections to Professional F's employment, however, the debtor's plan was confirmed. After confirmation, the debtor and professional F withdrew the original application and then filed a new application. This new application sought non-protunct relief and disclosed an additional 3,000 client and investment connections. These included several investments in funds that were the secured creditors of the case, who had acquired the debtor's assets through the plan. Case 7. Professional G was retained as a professional for the debtor in a Chapter 11 case. In support of the employment application, Professional G submitted the declaration of the partner who supervised the investigation of Professional G's connections. The partner, however, was not working on the case and had no bankruptcy training or experience. This partner's investigation and disclosure of Professional G's connections in the case was restricted in the following ways. Even though the firm has over 100 wholly owned and managed affiliates, and even though the firm holds itself out to the public as one firm, the partner investigated and disclosed the connections of only the 6 affiliates within the firm's organization that staffed the engagement. The partner also investigated and disclosed only the connections that resulted from a direct commercial relationship, a limitation not found in Rule 2014. He thereby excluded, for example, the personal investments in interested parties held by the firm's partners and employees, as well as other client relationships, litigation parties, other adverse interests. And even though the firm does have a substantial and successful business in data analytics, it does not have a modern conflicts checking software program like other substantial professional firms do. Case 8. Professional H was retained as a professional for the debtors in 13 Chapter 11 cases from 2001 through 2018. In each of these cases, its engagement agreement stated, "Nothing in this agreement is intended to create, nor shall be deemed or construed to create, a fiduciary relationship." In 2016, a bankruptcy judge explicitly rejected Professional H's argument that it is not a fiduciary in its Chapter 11 cases and held that it is indeed a fiduciary. Nevertheless, in 3 subsequent Chapter 11 cases, Professional H continued to use this language in its engagement agreements. Case number 9. Professional I was retained as a professional for several affiliated debtors in their Chapter 11 cases to assist them with, quote, operational transformation, close quote, that touches, quote, on many aspects of the debtor's operations, close quote. The debtors and Professional I requested the court's approval for the debtors to pay Professional I a fixed monthly fee as a, quote, ordinary course professional, close quote. These cases are real cases. Each of these cases has happened, although I have simplified them a bit for brevity. Some of these cases are still happening today. Each of these cases has significant problems under Rule 2014 and Section 327. Each of these cases presents a threat to the integrity and fairness of the bankruptcy process. There are not, however, professionals A through I. It is only one professional that has committed all of this conduct and other similar conduct. That one professional is McKinsey. McKinsey is the one professional that has decided that it is different, that all of this conduct is just fine. But it is not fine. It's unethical, it's illegal, and it's dangerous. Other professionals understand that the principal responsibility of a fiduciary in bankruptcy is to maintain and promote the integrity of the bankruptcy system in this country. But McKinsey's conduct demonstrates that it does not understand that. Other professionals understand that to meet that principal responsibility, professionals must be fully transparent in disclosing all of their connections, as Rule 2014 requires. McKinsey's conduct demonstrates that it does not understand that. Other professionals understand that a fiduciary in a bankruptcy case owes its full loyalty to the court, to the bankruptcy process, and to the bankruptcy estate. Again, McKinsey's conduct demonstrates that it does not understand that. And other professionals understand that this duty of loyalty prohibits any conduct that even appears to benefit itself, another client, or any other party, financially or otherwise. McKinsey's conduct demonstrates that it does not understand that. When Justice Cardozo was a justice on the on the New York Court of Appeals, he was wise teaching about the honorable and trusted place of fiduciaries in the view of the law. And the United States Supreme Court subsequently cited and quoted this teaching with approval in 3 cases. Justice Cardozo wrote, "Many forms of conduct permissible in a workaday world for those acting at arm's length are forbidden to those bound by fiduciary ties. A trustee is held to something stricter than the morals of the marketplace, not honesty alone, but the punctilio of an honor the most sensitive is then the standard of behavior. As to this, there has developed a tradition that is unbending and inveterate. Uncompromising rigidity has been the attitude of courts of equity when petitioned to undermine the rule of undivided loyalty by the disintegrating erosion of particular exceptions. Only thus has the level of conduct for fiduciaries been kept at a level higher than that trodden by the crowd. It will not consciously be lowered by any judgment of this court." McKinsey's conduct in its Chapter 11 cases has not met the high standard of behavior that Justice Cardozo prescribed. Rather, in Justice Cardozo's words, McKinsey's conduct has been that trodden by the crowd. It may be permissible in a workaday world for those acting at arm's length, but it is forbidden to those bound by fiduciary ties. And here is the irrefutable proof. For its conduct in 3 bankruptcy cases, McKinsey has paid a record-breaking $32.5 million in sanctions, including an astonishing $22.5 million in one of those cases. Yet, McKinsey still does not understand and accept what other professionals know at their very core, that the law holds professional service in bankruptcy to a higher standard than service elsewhere, that it is an honor to be approved by the court to serve in the high position of trust as a professional and a fiduciary in a bankruptcy case, and that this honor is not bestowed merely by default or by reputation alone. It is earned by demonstrated commitment and by right conduct. And so the struggle continues. It continues in the litigation against McKinsey in the Westmoreland coal case in Houston, in which J. Alex and the United States trustee are fighting to protect the institution of bankruptcy. I am proud and honored to serve as one of Jay's attorneys in that litigation. After almost 30 years on the bench, I retired back in 2015, but I accepted Jay's request to help him deal with McKinsey because I could not remain idle in the face of McKinsey's misconduct and the threat that it posed. Our bankruptcy system is too important to our economy for us to remain idle. Our bankruptcy system is too important to the welfare of our people of our country for us to remain idle. It is our duty as professionals to act against any threat to our courts. And this is now as urgent as ever. Our bankruptcy system is about to be severely tested and stressed. And so we, and I say we here because on this point I also speak for my client. We look forward to the day when McKinsey makes the choice that virtually every other professional has made, the choice to enter the honored association of bankruptcy professionals who know in their minds and in their hearts, and who demonstrate in their conduct what it means to be a trusted and honored fiduciary in a bankruptcy case. Only then will McKinsey live up to Justice Cardoso's lofty prescription. And when McKinsey makes that choice, the choice we have been asking it to make for 6 years now, it will be welcomed into that honored association. Thanks to you for listening, and thanks to the ABI for this opportunity.